Hello, can the jail staff hear me?
Yeah, what you need us for?
I was supposed to interview Arthur Barber and I still have not.
I know you haven't interviewed him because we needed a wheelchair to get him and no one has a wheelchair. So
Okay,
somebody may go up later on with a phone or whatever. If not, we're gonna have to medical reset him.
okay, all right, thank you.
All right.
All right, good afternoon, everyone. It is now 2 p.m. This is the state expedited accusations calendar. This calendar is for those individuals who have been recently arrested, that the cases have already been formally accused and bound over to state court. All participants, this particular proceeding is being broadcast over the internet, and it is also being live streamed. That means that any member of the public can log on and watch this proceeding. All defendants, you have an absolute right to remain silent. Anything you say regarding the facts of the case can and will be used against you. You also have a right to an attorney at this proceeding here today. Those who receive a cash or surety bond today will be reset to the state all-purpose calendar on August the 5th of 2022. Those who receive a signature bond will be reset further notice for further adjudication. Are there any announcements at the jail before we begin? Any medical resets that we are aware of? All right, hearing none, I'll assume there are none.
Position number 1.
Position 1 is a medical reset?
Yes, ma'am.
All right. Are there any other announcements? Have all other defense attorneys had the opportunity to speak with their clients?
Your Honor, we have, I think Mr. Barber was mine, but could someone from the staff send me, and I don't know if Miss Helen has received either the calendar.
The calendar went out this morning. The add-on only went out recently, so you should have the email. The calendar went out this morning surprisingly early, and we have an extensive calendar today, so I'd like to get moving if we can.
Judge, we got the link, but we did not receive the calendar.
I don't know how that's possible because I got one. Can someone send, I'm not contesting what you said, I just find that unusual because usually I am the last one to get anything. So if someone could send Mr. Ford and Miss Helen the calendar, I would greatly appreciate it. And I understand we do not have a conflict attorney today, so that may also present some challenges. Oh, the reset date is August 4th, not the 5th. I apologize. I just got the information. Those who receive a surety or cash bond will be reset August 4th, not August the 5th. All right, further before we begin, are the defense requesting breakouts for any positions? I'd like to do the breakouts first, whereby those tend to go faster. No breakouts, Ms. Helen? Mr. Ford, any breakouts? Is the state requesting any breakouts?
None, Your Honor.
Okay, I'm assuming no breakouts from the state.
No, Judge.
All right.
Position number 7, Your Honor, I just wanted to see if the defense wanted to waive sounding of the charge.
Well, we don't have.
I waive sounding anyway. I don't read those charges, but I'm just trying to make sure that if a breakout, does anyone believe a breakout will be necessary for position 7? If so, I'd like to do that first.
Position number 7, we were still gonna be reset because there's no conflict attorney.
We're not resetting the ones without conflict attorneys. I'm gonna hear those and see if I can set bonds. And if not, if I do not feel that I can give them a signature bond, they'll be reset to Monday, such that they don't have to sit in jail if unnecessary. So please bring those who don't have conflict attorneys, if possible, to court today. If I can get them out of jail or assign a bond, I'd like to do so. All right.
Okay, we're ready to get started because I don't want the smoke detector to go off again, Judge, like it did on last Saturday and hold us up for court. So
It will not hold us up. Yes, if it does go off, Mr. Jordan, will you go ahead and put the transcription on so that the defendants can read what's happening? We will not stop due to the fire alarm. All right, I'm gonna get us out of here. We're gonna move this calendar. All right, who do I have first?
Position number 10, please, in courtroom 3.
All right, good afternoon. Are you Triana Hinton?
Yes, ma'am.
All right, Ms. Hinton, your case number is 22 CR 004833C, in which you're charged with 1 count of simple battery family violence and 1 count of criminal trespass with the offense date of July 22nd, 2022. Do you understand your constitutional rights?
Yes, ma'am.
All right. Ms. Roberts, can I have that history, please?
She has 3 cycles. Last arrest was in 2005 for probation violation. Doesn't state the underlying charge. It appears to be a misdemeanor. And nothing further, no convictions on her. Well, I don't see the conviction for that probation violation.
And I apologize. I know you sent me an email with recommendations. I didn't have a chance to review it before court. If you would tell me whether or not the defendants are recommended. Is she recommended?
She is.
All right, thank you. Whose case is this for the state?
That's,
That would be my case, Your Honor.
All right. Oh, it's good to see you, Ms. Waldrop. Been quite some time.
Yes.
All right. What is the state's recommendation?
Yes, Judge. The state's recommendation for bond on the count of simple battery family violence is a $1,500 good bond. On the count of criminal trespass that was added, it's a $1,000 straight bond. And then we'd also ask that the defendant have no further contact with Mr. Richard Tofia, no drugs or alcohol while out on probation, and no weapons on or about her person.
All right. Very briefly, will you give me a summation of the factual basis, Ms. Waldrop?
Yes, Judge. Brief synopsis of the factual basis. Mr. Tofia was sitting at the corner of Ward and Roselle streets in Fulton County when the defendant actually pulled up in a vehicle, got out, walked over to him, and then struck him with her hand and then threw a chair at him.
Ms. Hinton, I advise you not to say anything. It'll all be held against you, okay? So any statements or anything from you, please hold that. Thank you.
Let's mute it courtroom 3 so we can keep going. All right, go ahead. I'm sorry, Ms. Waldrop.
She also threw 2 bricks at his vehicle, causing some scratches. Additionally, he had a slight scratch on his neck, Judge.
The allegation is she got out of a car and threw a chair that was at his residence is the allegation, Ms. Waldrop?
Your Honor, I'm not exactly sure where the chair was located.
Okay.
But yeah, he did pull up in a vehicle.
Okay, that's interesting. All right, thank you. I think I understand. I'm going to sound for Mr. Tofia. Mr. Tofia, if you are present on this Zoom conference and wish to be heard, this is your opportunity to speak. All right, hearing none. Ms. Helen, if this is your client, please proceed.
Yes, Your Honor, this is my client. She's 39 years old. She has just recently graduated from Atlanta Tech with an associate's in psychology, Judge. She does have 2 children, a 6-year-old son. That 6-year-old son she does share with Mr. Tofia. She does have another daughter that she is a primary caregiver of. She is a lifetime resident of Fulton County, was born at Grady Hospital. And again, I mentioned that she does have 2 children. Judge, in this case, I don't know if you read that police report, but Miss Hinton showed up to have a conversation for Mr. Topia because he was supposed to pick up their 6-year-old son. He had not done so. She went to the location, which was a stoop. It was just a corner. He was sitting on the corner. She walked up directly to him and asked him about where he was to be able to pick up the child. The conversation did become physical when Mr. Topia grabbed her under her right arm, to which she does have a purple bluish scar, which the officer also noted in that police report. And he pushed her against the car, asking her to leave. So I did read that police report. That officer did say that there was a video Mr. Topia did give to him, Judge. But when I spoke to Miss Hinton, she showed up to have a conversation. Mr. Topia got violent. And so, Judge, we are asking for a signature bond of no more than $1,000 for the simple battery, and then $500 for the criminal trespass. That'll be a total signature bond of $1,500. I do believe pretrial services says that she does qualify. And again, Judge, just the bond factor, she's going to come to her court dates. She is not going to have any contact with Mr. Topia. It's not going to intimidate any witnesses, and it's not a danger to our community, Judge. And she is not going to reoffend while out on bond. So we are asking for that signature bond.
All right, thank you. At this time, Ms. Hinton is going to receive a $3,000 signature bond through pretrial services, $1,500 for each charge. She is to take a 1-day anger awareness course and to have no further contact with the alleged victim in this case. She can arrange transport of the child through a third party, and she is to have no weapons, drugs, or alcohol as a condition of that signature bond through pretrial services. Is there anything further from either the state or the defense as it pertains to this case?
No, Your Honor.
All right,
Okay.
hearing none, best of luck to you, Ms. Hinton. We can
Thank
move
you.
to the next position.
Position number 12, Judge, please.
All right. All right, are you, pronounce your name for me, please?
Fatumata Kumara.
All right, Ms. Kumar, your case is 22 CR 004827A, in which you're charged with simple battery with the offense date of July the 22nd of 2022. Do you understand your constitutional rights?
Yes.
All right, thank you. Ms. Roberts.
She only has 1 prior arrest, which is from 2012 for driving without a valid license and criminal damage to property. That was a first offender, and it was sealed in 2016 out of Gwinnett County. She is recommended.
All right, thank you, Ms. Roberts. Ms. Williams, is this your case, or is it you, Ms. Waldrop again?
It is going to be me, Your Honor. Ms.
Okay,
Waldrop.
Ms. Waldrop, please proceed.
Yes, Your Honor. Just a brief factual basis. Ms. Kamara, as well as the other position on the calendar, Ms. Sabri, were roommates. They had been arguing several times throughout the day. It turned physical. And both ended up being arrested and had physical injuries. With regard to Ms. Kamara's case, based on her history, the state's recommendation on bond on the simple battery count is a $2,000 good bond. We would ask that she stay away from the location of 6558 Roswell Road and have no further contact with Ms. Rashida Sabri.
All right, thank you. Ms. Helen, well, she's a cross defendant. I can't sound for her. So Ms. Helen, please continue.
Yes, Ms. Kamara is 31 years old. Currently, she works for Morgan & Stanley, is working from home for the last several months. Before that, she was at American Honda, so she's very employable. She has a high school degree. She is from Sierra Leone, but has been in Georgia for the last 15 plus years. And she does have a 7-year-old daughter. So to give a little bit more information, not too much, Ms. Kamara was renting her 7-year-old daughter's room to Ms. Sabri. Prior to this, Ms. Kamara wanted to give her notice to move out. She did 3 months prior to July 21st. She gave her written notice to vacate. At this point, Ms. Kamara was keeping all distance from Ms. Sabri. In fact, She had her friend, Miss Jennifer Rodriguez, which is mentioned in the police report, to come over and just make sure that she didn't have to have any direct contact with Miss Sabree. When she asked Miss Rodriguez to get her things from downstairs in the pool, Miss Sabree offered calling her bitches and all types. Back into the fight, into the verbal argument, Miss Sabree punched Miss Kamara in the face. Miss Kamara was trying to defend herself. Miss Kamara was not the initial aggressor of this. That is her home at 6558 Roswell Road. I think it's Springs, Smyrna Springs. I'll have to get that address, Judge, but it's apartment 1326 30328. And when she asked this tenant to leave, that tenant became violent. And so, Judge, she is putting in a civil order to evict Miss Sabree, but we are asking for the stay away for Miss Kamara, stay away from that address to be removed, but that Miss Sabree not be allowed to come back to that address, except for a one-time escort to remove all of her things from that property, Judge. We are also—
Miss Helen, I'm going to interrupt for 1 second before we get away from that. Miss Waldrop, was the information that you had that this was the home of this defendant and not of the cross defendant, or did you have the information that this was the cross defendant's home?
Your Honor, I did not have information with regard to exactly whose residence it was, but both were residing there. So as far as ownership, I don't think I had that information.
All right.
Judge, I have a lease from Miss Kamara stating that that property is in her name. We were also afraid to have Miss Sabree come back to that property because of her 7-year-old daughter. That's her room, and she was afraid of violence from Miss Sabree towards her daughter. Again, Judge, we are asking for a $1,000 signature bond. She does qualify for pretrial services. The bond factors, the Ayala factors, she will come to all court dates. She understands the seriousness of these charges. She will not be rearrested. And Judge, I do believe, again, she does qualify for that signature bond.
All right, thank you. Because Ms. Helen has indicated that there is a lease that in fact indicates that this is a defendant's home, and she is an officer of the court, we are going to remove the stay away. At this time, the defendant will receive a $6,000 signature bond through pretrial services. She will also complete a 1-day anger awareness course, and she is to have no weapons, drugs, or alcohol as a condition of that signature bond through pretrial services. All right, is there anything further from either the state or the defense as it pertains to this position?
Just to ask, will Miss Sabree be given a one-time escort to remove her things from the property, or Miss?
We'll take that up. We'll take that up when we get to Miss Sabree's case, who also appears on this calendar today.
Yes, Your Honor.
All right. Are we able to do Miss Sabree next at the jail, since we've
Yes,
already had
ma'am. She's here at the South Annex.
That would be ideal. Miss Sabree, has South Annex heard their rights?
Yes, ma'am.
All right, wonderful. Good afternoon, Ms. Sabree. Oh, I apologize before I begin. Ms. Waldrop, did you have anything further for position 12?
No, Your Honor.
All right, thank you. All right, Ms. Sabree, your case number is 22CR004826J, in which you're charged with simple battery. Do you understand your constitutional rights?
Yes, ma'am.
All right, thank you. Ms. Waldrop, we have a little bit of the factual basis as we just covered position 12. But please proceed. But Ms. Roberts, please give me the history first. I apologize.
She has 2 cycles, with the last arrest being January of 2021 for battery out of Clayton County. That case appears to be an open case out of Clayton County. Then her first arrest was an aggravated assault from 2015, which was a first offender. It was sealed April of this year.
All right, thank you. Ms. Waldrop.
Yes, Judge. You having heard the facts and the history, the state's recommendation is on the simple battery count, a $3,000 straight bond. We would ask that she stay away from the address of 6558 Roswell Road, have no further contact with Fatoumata Kamara, the cross defendant in the case, as well as no weapons, no drugs or alcohol.
All right. It is my understanding that there is no conflict defender, and Ms. Sabree would have needed a conflict defender today. Is that correct? All right. She's conflicted out from the public defender's office. Ms. Sabree, what that means is you have a right to an attorney today. And if I didn't feel that you qualify for a signature bond, I'm going to give you a bond. And if you don't make it, you'll be reset as well to the calendar on Monday, whereby your case will be revisited. All right. Having heard your history, I am going to accept the state's recommendation. You're going to receive a $3,000 surety bond. Your case will be reset to Monday as well, in the hopes that a conflict attorney will be present to assist you at that time. You must stay away from 658 Roswell Road. You can return one time with a member of law enforcement to get any items that may still be at that location. And you are to have no further contact with Ms. Fatima Kamara. And Ms. Fatima Kamara is also to have no further contact with you as well. You are to have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further from either party?
No.
All right, best of luck to you, and we can move to the next position.
Position number 5.
All right, are you Alicia Cunningham?
Yes, yes, Your Honor.
All right, Ms. Cunningham, your case number is 22 CR 004829E, in which you're charged with battery, family violence, and simple battery, family violence, each with the offense date of June the 11th of 2022. Do you understand your constitutional right?
Yes.
All right, thank you. Ms. Roberts?
He has one prior arrest from December of 2021. It is for battery family violence. It is an open case, 21 CR 007348E. That is a pretrial case. We're surrendering that bond, and I believe it's the same victim as today's case. Marcus Jackson was the victim from the December case.
Okay, thank you. Ms. Waldrop, is this your case as well?
This will be Miracle Williams for the state, Your Honor.
Oh, Ms. Williams, please give me the state's recommendation.
Yes, Your Honor. The state's recommendation on this case is a $20,000 good bond on the battery family violence and a $5,000 good bond on the simple battery family violence. No further contact with Marcus Jackson. And another stay away from 500 East Ontario Avenue, Southwest Atlanta 30310, and third-party transfer of the children.
All right. And very briefly, Ms. Williams, will you give me the factual basis, particularly in light of that high request?
Yes, Your Honor. There is another open case, case number 21 CR 007348E, also for battery family violence, also with the same victim, Mr. Marcus Jackson. In this case, Your Honor, on June 6th of this year, officers met with Marcus Jackson, who advised that he came home. And once he got there, he saw his current wife or ex-wife, the defendant's vehicle blocking the driveway. He did advise that he was aware that she was there to pick up their child or children. He came in and asked her to move her vehicle. She refused to do so and immediately began to attack him. She tore off his shirt and caused visible injuries to the defendant. The officer did see lacerations on his right ear and his wrist. And she also, during that altercation, grabbed his genital area, where he also advised that there was some type of skin peeling that occurred because of that. So our bond, Your Honor, is asking to be a little higher in that this is another case. And in the original bond, in the aforementioned case, there was also a no further contact. There was also a stay away from the exact same address. There was also an ask of third-party transfer of children, Your Honor. So it's obvious that this defendant is not abiding by the bond that was issued by the court against this same defendant, Your Honor, at this same address.
All right, thank you. I'm going to sound for Mr. Jackson. Mr. Jackson, if you're present and would like to be heard, this is your opportunity to speak. All right, hearing none, is this defendant represented? Ms. Helen, do you represent this defendant?
Judge, good afternoon. My name is Deidre Stokes. I'm the attorney for Ms. Cunningham.
Okay.
Okay, all right, and you're at courtroom 1. All right, go ahead, Ms. Stokes. Thank you.
Good afternoon, Your Honor. Yes, we certainly object and disagree with the state's presentation. For the court's information, the December 6th incident occurred immediately after my client initiated a divorce action. So that's when all of this, that's really what all this is about. My client is a lifelong resident of Georgia. Her family is based in Rome. She also has family here in Atlanta. She has two very small children with Mr. Jackson. I believe the child is 7 years old and 3 years old. She is the primary caretaker for those children. Judge, the incident that the state is referencing, I'll just go back a bit. On the December incident, my client is adamant, and we plan to prove that it was a self-defense situation in which Mr. Jackson actually attacked her. Of course, the circumstance was that by the time the police arrived, my client wasn't there to present her side, and she actually went to the police station immediately upon finding out that he had called the police. So she presented herself to the police separate from when they arrived at the home. My client had bruising and marks, but of course, the police determined that they would press charges against Miss Cunningham. Now, the recent event that occurred, apparently there was a warrant issued as of July or June 11th. My client, of course, had no knowledge of that. I will state as an officer of the court, Judge, that Mr. Jackson asked Miss Cunningham to return to the home. He contacted my office directly, Judge, and said, she needs to come back home. I can't manage these children. I need help. So he asked her to return home. She did so just to take care of her two minor children. She's actually been living with her sister. Again, she does have family in the area. So she returned to the home. She was attacked by Mr. Jackson. Of course, at the time, she had no idea there was a warrant out for her arrest. So when she was getting her children ready to go to school, she was arrested because Mr. Jackson contacted the police in terms of this warrant. I don't know what occurred on June 11th, but my client has a number of bruises on her hips, her legs, her torso, her shoulder, because Mr. Jackson actually put her out of the home with the minor children. She was in her robe, Judge, with no shoes, and he put her out of the home with the two children, took her phone and her keys. And that's why he was able to call the police. My client left the residence because she obviously was fearful for what might happen. When she returned to make sure the children were okay and take them to school, that's when the police showed up and she was arrested. So, Judge, we certainly would ask the no contact and not returning to the residence is absolutely reasonable for the state, but the $20,000 bond is completely above board, unreasonable. Ms. Cunningham is the victim of an abusive situation because she is now trying to divorce this man.
Is she currently employed?
She is, Judge. She's actually a licensed nurse. She's well educated. She's a contract nurse, so she doesn't have ongoing employment, but she actually is a licensed nurse. She has a new contract that she's just obtained, so she does need to be released for the purposes of returning to her job.
All right. I think I have enough information. At this time, the defendant is going to receive a $6,000 surety bond, broken down 5,000, count one, 1,000, count two. She's to have no further contact with the alleged victim in this case, last name Jackson. They can arrange third-party transport of the child and follow any orders issued as part of their divorce proceeding. She is also stay away from the address on Ontario Avenue and have no weapons, drugs, or alcohol as a condition of that bond. She will also be reset to the SAP calendar on August the 4th, whereby this bond can be revisited. Is there anything further from either party?
No, Your Honor.
Nothing further from the state. Your
All
Honor.
right, best of luck to you, Ms. Cunningham.
Thank you. That'll be
All
all
right.
for South Phoenix, Your Honor. May we be excused?
Yes, have a great afternoon.
Thank you,
Who do we
Judge.
have next?
Your Honor, before we move on, there was I've just been contacted by Mr. Jordan's office that there's an add-on that was mistakenly left off the pull sheets. I have now received the information for that person. I will have to have a breakout session because that person, Mr. McCullough, would have to be interviewed.
Can you
apologize,
call
but
the
we
jail
just-
as opposed to a breakout so we can keep going, if
if it-
possible?
If there's a number someone can give me, because I've been calling today.
Call court 11-612-2385, 404-612-2385.
612, what's the last four numbers?
2385.
And Mr. Ford, what positions do you have so we can go to a position that's not yours?
I have the early calendar, Your Honor. I have all the way up to 9, I think.
Okay, so if we can go to a position after number 9, I'd appreciate it. Who do we have next?
Position 13, Marshall.
All right, good afternoon, Mr. Marshall.
Good afternoon, Judge.
Your case number is 22 CR 004830H, in which you're charged with simple battery against either an older person who is older than 65 or a pregnant person. I'm sure we'll figure that out momentarily, as well as one count of simple battery family violence with the offense date of March 21st of 2021. Do you understand your constitutional rights?
Yes, ma'am.
All right, Ms. Roberts.
Yeah, 17 cycles. Last arrest was September of 2019 for driving while license suspended or revoked. Has a probation violation. That 2019 case was a no-low plea. Has a 2015 probation violation. The underlying charge is not listed, but it was a felony. He had a conviction from 2014 for possession of tools for commission of a crime. A 2003 probation violation, a 1998 simple battery conviction, a 1997 theft by receiving stolen property, sale of marijuana, possession of a firearm or a knife during commission of or attempt to commit certain felonies, and carrying a concealed weapon conviction.
That's sufficient. Thank you, Ms. Roberts. I think I have a clear picture. I appreciate that. All right, Ms. Williams, is this your case or is it Ms. Waldrop? I always seem to get that wrong. Is it you, Ms. Waldrop?
It's me. Yes, it'll be mine.
All right, Ms. Waldrop, please proceed.
Yes, Judge. As you heard, he is charged with one count of simple battery against a person 65 years or older. And that is for an incident that occurred when he arrived at his mother's residence, confronting her about some money that he wanted, and she didn't know what he was talking about. He ended up taking his hand and grabbing her around the neck. At that point, Miss Carol Banks's roommate came and was able to get him off of her. She did not sustain any visible injuries, but Your Honor, based on the allegation and the history, certainly the state's recommendation on the simple battery against a person 65 years or older is a $7,500 straight bond. And on the simple battery family violence, it's a $5,000 straight bond. We would also ask that he stay away from the address of 1540 Olympian Circle, have no further contact with Ms. Carol Banks, have no drugs or alcohol, and no weapons on or about his person while on bond.
All right, thank you. Ms. Helen, is this your case?
Yes, Judge. Mr. Marshall is 46 years old. He's very employable right now. He's looking for more employment that's going to begin August 1st of this year. He is a forklift driver, has been so for the last several months, making $21.50 an hour. He is a high school graduate of Benjamin Mays High School. He is a lifetime resident of Fulton County. Muskogee Hospital is where he was born, Judge. And he does have 6 children, 7-year-old girl, 9-year-old son, a 10-year-old son who is disabled. He is the primary caregiver of that son, 14-year-old girl, and then 23-year-olds that he also does provide financial care for, a son and a daughter. So Judge, I did hear his history. The last simple battery or violent charge was over 23 years ago. Judge, we are asking for a signature bond. I did reach out to Miss Carol Banks. Mr. Marshall stated that he believed that they had resolved this and talked with mom about it. When I called Miss Banks, she wanted to appear for this court hearing. She is elderly. She was not able to. So I gave her number to the victim advocate who stated that they reached out to her. I believe Miss Banks would like no further violent contact, but if the advocate could speak to that. I did speak to Ms. Banks. She said that she did want to talk to Mr. Marshall and have contact with him. But Judge, again, we are asking for that signature bond. I do have a permanent address and contact number, but again, he does not have a violent history and the Ayala factors. He will come to court. He does understand the seriousness of these charges. He will not reoffend. He will not, there's no intimidation of the witness, Judge. And so again, we are asking for that signature bond.
All right, thank you. I am going to sound for Ms. Banks at this time. If Ms. Banks herself is present on the line, I will hear from Ms. Banks. All right, hearing none at this time, the defendant is going to receive a $5,500 surety bond, broken down 3,000 count one, 2,500 count two. He is to have no further contact with the alleged victim, in this case, last name Banks, and must stay away from the address on Olympian Circle. He is to have no weapons, drugs, or alcohol as a condition of that surety bond. His case will be reset to the SAP calendar on August the 4th, whereby this can be revisited at that time. Is there anything further from either party?
No, Judge.
No, Your Honor.
All right, best of luck to you, sir. Who do we have next?
Next is position 16, y'all.
All right, are you Stefan Young?
Yes, ma'am.
Mr. Young, your case number is 22 CR 004825A, in which you're charged with 1 count of simple battery family violence, 1 count of criminal trespass and damage to property, and 1 count of willful obstruction of a law enforcement officer, each with the offense date of July the 22nd of 2022. Do you understand your constitutional rights? You're waving your hand. You do understand your rights. All right. Ms. Roberts?
Has 3 cycles. Last arrest was April 12th for a FTA. He does have an open case out of Fulton County for battery, family violence, and cruelty. That case number is 22 CR 002153A, and that is a pretrial bond, so we are going to surrender that bond.
All right. Thank you. Ms. Waldrop.
Yes, Judge, and I do want to point out that that open case that is assigned to Judge Roth involves the same victim as the case that is before you today. Based on that and the other history that you heard recited from pretrial, the state would be requesting on the simple battery a $3,000 straight bond, and on the criminal trespass a $1,500 straight bond, and on the obstruction a $1,000 straight bond. Your Honor, the allegation based on the facts and the warrant are that the defendant broke the victim's phone and then attacked her. He fled from police on foot as they attempted to detain him. We would also be asking, as part of the bond condition, that he stay away from the location of 6854 Fireside Lane. We would ask that he have no further contact whatsoever with Desti Gonzalez, the victim in this case, as well as the other open case, and have no drugs or alcohol and absolutely no weapons on his person while out on bond.
All right, thank you. I'm going to song for Ms. Gonzalez. Ms. Gonzalez, if you are present on this Zoom conference and wish to be heard, this is your opportunity to speak. All right, hearing none, we'll go to Ms. Helen.
Yes, Judge, and I do believe I did send the link to his mom. I just want to sound to see if his mother is present on the call.
Even if she's present, I don't intend to hear from her, as she's not the victim at this time, Ms. Helen, but she can observe.
Sure, Judge. Today I'm asking for a signature bond for Mr. Young. He's 21 years old. I did hear the history that is still an open case, Judge. And so just getting to the Ayala factors, I do hear the open case, Judge, but I stress to him the importance. Again, there is a no contact with Ms. Gonzalez. So I do not believe that there's going to be intimidation of the witness. He is not from Georgia. He's from New York, but he has been in Georgia for the last several months working. He was working previously at an overnight packaging warehouse, but then he's recently been hired at UPS and just recently received that job, Judge. He does have his GED from New York, and he does share a 1-year-old child with Ms. Gonzalez. We are asking for a signature bond for all 3 cases, no more than $1,500. Mr. Young has no income. He does have these jobs that if he's allowed to be released, he'll be able to secure them. But at this point, he has no income. So he's not able to afford a $3,000 surety bond. So Judge, we are asking for that signature bond. And we are asking that it be $1,500, Judge.
All right, understood, Ms. Helen. At this time, Mr. Young is going to receive a $2,500 surety bond. It will be $1,500 count one, 500 count 2, 500 count 3. So that should equal the $2,500 surety. He is to have no weapons, drugs, or alcohol, and no further contact with Ms. Gonzalez. They can arrange transport of the child through a third party. He must also stay away from the address on Fireside Lane and have no weapons, drugs, or alcohol as a condition.
Last point, the only reason, well, I wouldn't say the only, the reason I had mom show up, 6854 Fireside Lane, Atlanta, Georgia, 30301 is her leased property. That is her home. So we are asking that he not be forced to stay away from that location and that she is on this call to verify that her ownership of that property.
All right, my question will be, Ms. Waldrop, is it your contention that the victim resides there as well?
It is, Your Honor.
All right, I'm gonna hear from the mother for the very limited purposes of that. If the mother is present on the line, what is the mother's name?
I believe that's Angela Waldrop. Is that the account?
No, that is Miss the ASG in this case. Who is the mother of this defendant?
Is it iPhone? Mr. Young, give me your mom's first name.
Aisha Phillips.
Aisha?
Okay,
Oh, there
Ms.
she
Phillips, I see you on the Zoom conference. All right, please raise your right hand and unmute your screen. Ms. Phillips? All right, I see that you've unmuted. Can you please raise your right hand and lower the camera so that we can see you and identify you, please? All right, you're not joined.
Hello?
Yes, we can hear you. Please raise your right hand. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, what is your address, ma'am?
6854 Fireside Lane, Atlanta, Georgia, 30349.
All right, does Miss Destiny Gonzalez reside at that location?
No, she is not at this location anymore.
Anymore, but she did reside there.
Months ago, when
Okay.
the first case happened. Yes.
All right, what will happen then is we're gonna say that Mr. Young can return one time with a member of law enforcement to ascertain whether or not the alleged victim resides there. If the alleged victim is there at that time, he must stay away from that address. However, if she is no longer there, he can return to that location. All
That's
right,
fine.
is there anything further from either the state or the defense as it pertains to this case?
No, Judge.
All right, best of luck to you, sir. Best of luck to you, ma'am. Have a great afternoon. That will
Yes, you too.
conclude Mr. Young's case.
Yes, thank you.
All right, who do we have next?
Position 2, Black.
All right, are you Quintez Black? I hope I'm saying that correctly, Mr. Black. All right, your case number is 22 CR 004822B, in which you're charged with criminal trespass with the offense date of July the 22nd. Do you understand your constitutional rights?
Yes, ma'am.
Thank you. Ms. Roberts?
He only has one prior arrest. I'm sorry, he has 3 cycles. His last arrest was from 2017 for simple battery and disorderly conduct. Those cases were dismissed. His first arrest was also for criminal trespass, also dismissed.
All right.
He was recommended for UJR.
Thank you so much. Ms. Williams?
Yes, Your Honor. The state recommends a $1,000 good bond, a stay away from the Sheraton Hotel at 165 Cortlandt Street in Atlanta, Georgia. On this day, Your Honor, July 22nd, Officer Sawyers was dispatched to the Sheraton Hotel where he did meet with Mr. Arquentes Black in the hotel lobby area. Mr. Black was asked several times on several occasions to leave the property of the Sheraton Hotel by the security officer, Mr. Michael Weeks, who was at the location, but the defendant refused the request. The defendant was also asked by the officer to leave and refused as well.
All right, thank you. Mr. Ford?
Thank you, Your Honor. Your Honor, my client is a high school graduate. He's 28 years old, been a resident of Georgia for over 10 years. Your Honor, in this case, my client was a resident of the Sheraton for 3 days. he was given permission to stay there so he could remove his, after his term was up, he was given permission to stay there because he was trying to stay another night. And he had got clearance through another security guard who went off shift. So, Your Honor, this is just a misunderstanding. My client has a stable address here in Georgia, and he also has tremendous community support with his grandmother who lives here as well. As you could note from pretrial services, he does not have any type of criminal record at this time. This would be his first offense, even though he has 3 cycles. Those cases were dismissed. Your Honor, I think a signature bond, we're requesting a signature bond be granted at this time.
All right, thank you, Mr. Ford. At this time, Mr. Black's going to receive a $2,000 signature bond through the jail, and he must stay away from that Sheraton hotel. He is also to have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further from either party?
Nothing
Nothing
further,
further.
Your Honor.
All right, best of luck to you, Mr. Black. That concludes your case.
Thank you,
Who do we
Ms.
have next?
Mr. Ford, appreciate
Position
it.
number 3. Bold,
All right.
Howard, I'm sorry.
All right, good afternoon, Mr. Bowen. All right, your case number is 22 CR004824C, in which you're charged with battery family violence and simple battery family violence. Someone is unmuted and it's causing a really bad echo. Let's see. All right, thank you, whoever that was. I appreciate that. Do you understand your constitutional rights?
Yes.
All right, Ms. Roberts.
Yes, 36 cycles. Last arrest was December of 2018 for a probation violation in Baldwin County. He appears to be on probation out of Fulton County for possession of cocaine with intent to distribute, possession of marijuana with intent to distribute, and possession of a controlled substance and Schedule 3, 4, or 5 with intent to distribute. Case number 18 SC 158701. Disposition was in 2019, 7 years probation. He also appears to be on probation for criminal attempt to commit robbery and aggravated assault. Case number 18 SC 161358, same disposition date, 7 years probation. Prior to these 2 convictions, his last conviction was 2003 for sale of marijuana and possession of a firearm by convicted felon. And the rest of his convictions are in the 90s. If you like those.
No, that's sufficient. Thank you, Ms. Roberts. Ms. Williams.
Yes, Your Honor. In this case, the state recommends a $10,000 cash bond with regard to the battery family violence and a $5,000 good bond with regard to the simple battery family violence. A no further contact with Keisha Hurd and a stay away from 1575 Willis Street, Northwest Atlanta, 30314. Your Honor, the reason for this bond is that, again, as stated, he does have 37 cycles of arrest. He is a convicted felon. He has at least 3 failure to appears, at least 3 parole violations, and at least 4 probation violations, with the most recent being, it looks like 2018. He is currently on probation now, has a very high likelihood of reoffense, Your Honor. With regard to this case, on August 7th of 2021, Officer Smith got a call regarding a female that was assaulted at the address of 1575 Willis Street. The victim in that case was Miss Keisha Hurd, who advised that she was at her current boyfriend's house when the defendant, who is an ex-boyfriend of hers, knocked on the door stating that he knew that she was in there. He continued to knock for a while and then left, or the victim thought that he left. So when she went outside to walk to her car, he then pulled up very quickly, reached his arm through the window and grabbed her by the hair while he was still seated in his vehicle. He then got out of the vehicle, grabbed her by her neck and struck her head against the windshield several times, causing it to shatter. She did manage to get away from Mr. Bowen, but he picked up her cell phone and drove off with that. When the officer arrived, he did observe multiple injuries on Miss Hurd, including her forehead, lacerations to her ear, and marks on her neck as well. Again, Your Honor, this defendant has a very violent history with convictions for drug offenses, burglary, possession of firearms, Your Honor. And the most recent, we believe, is an open case for 2018 in Roswell PD for armed robbery. So we are asking that you do a $10,000 cash bond with regard to the battery family violence and a $5,000 good bond on the simple battery.
All right, I believe Ms. Willis is present on the line. Before I go to you, Mr. Ford, I'll go to you, Ms. Willis. I'm going to hear from you, but what I am most interested today is whether you wish to have contact with the defendant. If you'd like to speak, please unmute your screen and raise your right hand. All right, do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, what would you like to tell the court at this time?
I understand that the charges that are before him, but also these charges were a year ago. These issues occurred between him and I over a year ago. At this point, he is a positive co-parent that cares for my daughter well. We have, like I said, tried to repair this. This has been over a year. And at this point, he has good co-parenting standards with me. We have anticipated we were supposed to be out this weekend doing things for my daughter to prepare for her very first day of pre-K on the 1st. Dexter, we just spent the holidays together as a family. He has a significant other, but things have been amicable. He has been keeping the child, him and his significant other. So at this time, I mean, I understand the charges before him, but this will hinder everything that we have worked for to go forward. He's just gained willful employment. He has worked towards paying off his licenses. He's gained a vehicle. Everything has turned around to be positive. I understand everything that's on his chart, but that is not indicative of that person he is now. So I am asking you all that, although I'm the victim on paperwork, I do not want to further be the victim for my child as a mother. So I am asking that this court just shows a little leniency. Dexter has improved. He has matured to the level that I can honestly say that I am here not only as a victim, but a co-parent, as a friend of Dexter Bowen.
All right, thank you. I appreciate that. And I'm assuming that you're wishing to have contact and do not fear the defendant.
No, ma'am. He just spent days at my home just 2 weeks ago. So this is not a threat at all. I fear him in no kind of way. He is, like I say, an active participant and a needed participant.
Thank you. I appreciate it. I just don't want you to say too much because the state is listening. Sometimes people say things that may end up getting used against the defendant, but thank you for answering my question. I appreciate that. I'm going to go to you now, Mr. Ford.
And I'm sorry, I also have one other request. And again, I understand that this is against everything that the court has requested, but as far as the financial bond this week, like I need those funds for my daughter. It's just things happening that we just won't be able to do if I'm not allowed to try to get him out on security. It's just financial things that's in order that I really need his assistance with.
Understand it. All right, thank you. I appreciate those statements. Mr. Ford.
Thank you, Your Honor. Your Honor, my client is a graduate of Benjamin E. Mays High School. He's 52 years old. I start off with those two things because this is to show that the rehabilitative system in this country works. Mr. Bowen has had some issues in the past, and that's in the past, Your Honor. As you notice from pretrial services, there was nothing on his record that was, I think that was a conviction. I think it was 2012 or so. He is on probation still. He is gainfully employed at Carter's Lumber in Stockbridge, and he drives a forklift. And as you recall, Mr. Bowen, I did ask for some lessons because I do want to try to drive a forklift one day, just to have the experience. And so he's gainfully employed. He makes over $16 an hour. He is a person who helps financially support. He has two younger children that are 12 and 4 that he's helping out financially. He also has 3 adult children. He's been a lifetime resident of Georgia. He has tremendous community support. He gave me the telephone number of his mother, and you've heard from the complaining witness as well that he's doing well. He's trying to do things in a positive manner. He's trying to wipe those things that happened in the past out of what's going on in his life. He's given me a stable address, stable telephone number, email address, and you've heard from the complaining witness. He's a person who's doing well. And in speaking with him, he is definitely wants to be there for his children. He did speak about being there to help support the opening days, the first days of school for his child, to be there to support them by clothing, school supplies, and those types of things. Your Honor, even with the recommendation of the state, I am asking for a signature bond for Mr. Bowen. I think he's a person who's proven that a person can change. This is a case that happened over a year ago, and I think Mr. Bowen has proven that he's ready to move forward. That incident, the complaining witness has said, is not a concern now. It's been over a year. So, Your Honor, we're asking that Mr. Bowen be given a signature bond so he can keep his job. He just started that job 2 weeks ago, and and the family needs his financial support. So I'd ask that you take those things in consideration and give Mr. Bowen an opportunity to continue bettering his life at this time.
All right, thank you, Mr. Ford. I appreciate it. At this time, the defendant is going to receive a $5,000 surety bond, 2,500 count one, and 2,500 count two. He is to have no further violent contact with the alleged victim in this case and have no weapons, drugs, or alcohol as a condition of this bond. Is there anything further from either the state or the defense as it pertains to this case?
Nothing
Further
further.
from the state, Your Honor.
All right, hearing none, that will conclude Mr. Bowen's case. Best of luck to you, sir. All right, who do we have next?
Position 4, Mr. Brown, Michael Brown.
All right, Mr. Brown, your case number is 22 CR 004828J, in which you're charged with soliciting rides with the offense date of July the 22nd. Do you understand your constitutional rights?
Yes, ma'am.
All right, Ms. Roberts.
Showing 20 cycles. His last arrest was June of this year for reckless conduct out of DeKalb County. That case was a conviction. He has a probation violation from earlier this year. I'm sorry, from May of last year, he had a probation violation. He also had a probation violation from June of 2020, a criminal trespass conviction from 2019, a robbery conviction from 2012 out of Fulton County. He appears to be on probation for that case. It was 7 years confinement, 13 years probation. Case number 12 SC 107182. He has a 2006 conviction for burglary and 2 counts of financial identity fraud, FTA from 2006, a DUI conviction from 2006.
That's good. Thank you, Ms. Roberts. I think that's sufficient. I appreciate it. All right, Ms. Williams.
Yes, Your Honor. State recommends in this case a $2,000 good bond and a stay away from the area of Georgia 400 South ramp area. On July 22nd, Officer Baskin of APD was on patrol in that area and did observe the defendant stopping vehicles on the highway for the purposes of soliciting. Officer stated that he immediately recognized Mr. Brown because he had recently arrested him on July 14th of this year for the exact same offense. That's Atlanta Police Case number 2219-50759. And when checking his records, he also advised that they've offered Mr. Brown help through their policing alternatives and diversion program. He was given assistance with food, housing, job opportunities. He's been given written warnings, citations, and ultimately he's been taken to jail 21 times this past year alone on the at the exact location of the 400 southbound ramp, Your Honor.
All right, thank you. Mr. Ford.
Thank you, Your Honor. Your Honor, my client is 56 years old, and he has a bachelor's degree from Florida Tech, and he's a computer IT individual, very employable. I guess you do what you have to do to try to make it. And he's trying to do things so he can become employable and do the right thing. He has a valid driver's license, so he's able to, and a vehicle. So he's able to try to get some type of work. He's working very hard at that. He's been living in Georgia for over 32 years, Your Honor. This is not a violent criminal, Your Honor. I can see that the recommendations of $2,000 surety bond, Your Honor. We'd ask that that be converted, changed, or our recommendation be a $2,000 signature bond, so that Mr. Brown could go out and try to receive employment. I've spoken with him, and that's what he's trying to do at this time, is trying to get a job. And he does have a bachelor's degree, so he is very employable, Your Honor. So to stop this cycle, Your Honor, I think it's important that we give Mr. Brown an opportunity to find employment and get out of jail. So at this point, we're asking for a signature bond.
All right, thank you. At this time, Mr. Brown's going to receive a $4,000 signature bond through the jail, and he must stay away from that location on Georgia 400. Sir, do you understand that? Do not go back there. They do not want to see you there.
Never will be seen there again.
Don't go back there. All right.
No, ma'am.
I believe that concludes this case. Is there anything further from either party?
Nothing further,
Stay,
Your
Your
Honor.
Honor.
All right. Best of luck to you, sir. Who do we have next?
Position 6,
How you doing, Your Honor?
All right, pronounce your name for me, sir,
Joao
and your last name.
Setmeyer.
All right, Mr. Setmeyer, your case number is 22 CR 004831Y, in which you're charged with 1 count of battery with the offense date of July 22nd. Do you understand your constitutional rights?
Yes, ma'am.
All right, Ms. Roberts.
First arrest recommended with the cosigner. He's 18.
All right, thank you. Ms. Williams.
Yes, Your Honor. In this case, the state recommends a $15,000 good bond and no further contact with William Stevenson, as well as no weapons, drugs, or alcohol. In this case, Your Honor, on July 22nd of this year, Sandy Springs officers were dispatched to Roberts Drive in reference to a call with regard to discharging a firearm. When dispatched to the location, they saw a white Buick leaving, and the white Buick was the victim, Mr. Stevenson, and 2 witnesses, one including a 14-year-old that was sitting in the back seat. The officer immediately observed scrape marks on the elbow or forearm of Mr. William Stevenson and also bruising on his forehead. The witness stated that the defendant, as well as another Black male, was punching and kicking the victim after they had snatched personal property from his hands and took off running. So the victim then chased behind the both of them for a few blocks, and then they turned around and jumped on him. The driver of the Buick was the victim's girlfriend, and she was actually taking the victim to the hospital at that time that they were pulled over by the police. And the victim also advised that she did witness the attack, so she pulled up very close to the altercation area, hoping that they would stop kicking and punching him at that time.
All right. And I'm sorry, give me that amount again, Ms. Williams.
That was a $15,000 good bond, Your Honor.
All right, thank you. I'm gonna sound for the alleged victim, last name Stevenson at this time. Mr. Stevenson, if you are present and wish to be heard, this is your opportunity to do so. All right, Mr. Ford.
Thank you, Your Honor. Thank you for the clarification as well, because I was going to ask that same question. My client is 18 years old, Your Honor. He finished 11th grade, but he's going back to receive his GED at this time. He's gainfully employed at a warehouse called GAP Warehouse, and he's been working there for a little over 3 weeks. And he's concerned that he may lose that particular employment if he's not able to bond out at this time. He's a lifetime resident of Georgia. He's He has a vehicle, he has valid driver's license, he has community support. He's given me the number of his sister, telephone number of his sister. Your Honor, he's been here all his entire life. I think I've said that, but he has no criminal history, Your Honor. He has no criminal history, and I think when the facts and when this case are really dove into, they will see that my client really did not have a lot to do with this particular incident. So at this time, Your Honor, we're asking that a signature bond be granted, even though the state is at the pretrial services asked for a signature. I believe that he's 18 years old and he should be able to sign himself out on a signature bond.
All right, thank you. At this time, the defendant is going to receive a $3,500 surety bond. He is to have no further contact with the alleged victim, last name Stevenson, and he is to have no weapons, drugs, or alcohol as a condition of that surety bond. It will be reset to the SAP calendar on August the 4th, whereby that can be revisited. All right, best of luck to you, sir. Who do we have next?
Position number 8, Favors.
All right. Good afternoon, Mr. Favors. Your case number is 22 CR 004836A, in which you're charged with disrupting a public school, disorderly conduct, willful obstruction, and inciting to rioting, each with the offense date of September the 25th of 2021. Do you understand your constitutional rights?
Yes, ma'am.
All right, Ms. Roberts.
He has 6 cycles. Last arrest was January of 2019 for possession of marijuana less than an ounce. That was a conviction. And then he had a 2014 driving without a valid license conviction. And nothing further to add.
Okay, thank you. Ms. Williams?
Yes, Your Honor. The state recommends a $3,000 good bond on each charge, a stay away from all Atlanta public school events, including a stay away from Lakewood Amphitheater at 70 Clare Drive, Southwest Atlanta, no drugs, alcohol, or weapons. In this case, Your Honor, the defendant was attending a middle school football game where something apparently happened on the field, and the defendant then jumped over the rail and ran onto the field in the middle of the football game, speaking certain words that using profanity, saying that no one was going to mess with his brother. And doing so, it actually reignited whatever issue had been going on the field. Although that original issue had started to de-escalate before he jumped over the rail and went onto the field. Also, Your Honor, once police arrived, they asked several times for the defendant just to leave. He refused and instead went back into the stands and then was subsequently arrested.
All right, thank you, Mr. Ford.
Thank you, Your Honor. My client is a high school graduate. He also is self-employed. He does painting, drywalling. He lays tile. He's been doing that for over 2 years. He's a lifetime resident of Georgia. He does have 6 children that he's helping to support, ages 10, 8, 7, 5, 1, and he has a 10-month-old as well. He's 28 years old. He has a stable address. He's been in Georgia his entire life. He is married, so he has has community support. Your Honor, this is a definite misunderstanding. My client was coming to the aid of what was going on out there. It was de-escalated because of his efforts. At this point, Your Honor, we feel that he does not have any violent criminal history. We believe that a signature bond at this time is what we are requesting.
All right, at this time, the defendant is going to receive a split bond. It's going to be a $500 surety for count 1, a $500 surety for count 2, and counts 3 and 4 will be $500 surety each. $500 signature through the jail each, such that he has a $1,000 surety and a $1,000 signature bond through the jail, for a total of a $2,000 split bond. He is to stay away from all events at the Lakewood Amphitheater and not to attend any APS events as a condition of this bond. And he is further to have no weapons, drugs, or alcohol as a condition of that split bond. Is there anything further from either party?
Nothing further from the state, Your Honor.
All
Nothing.
right. Best of luck to you, Mr. Favors. Who do we have next?
Next is the add-on.
Which one? One or two?
I didn't receive it, so I don't know. Mr. McCallum.
Okay, that's position two. All right, thank you. Good afternoon, Mr. McCalla. I don't have your case number written because I got the add-on late. Hold on. 1 second.
I can give you that number if you like, Your Honor.
Yes, if you read that case number, Mr. Ford, just into the record for me.
Okay, that case number would be 22CR004838D.
And the charge is reckless conduct, correct?
That's correct.
All right, with the offense
Offense
date
date 38. I was going to give the offense date of 3822.
yes. Do you understand your constitutional rights, Mr. McCullough?
Yes, ma'am.
All right, Ms. Roberts. Ms. Roberts, if you're speaking, you're muted. We can't hear you.
Sorry. He has 14 cycles. Last arrest was July 7th of this year for driving while license suspended or revoked out of Clayton County. That case appears to be open. He had a 2016 conviction for possession of marijuana less than an ounce. A 2013 criminal trespass conviction, 2012 criminal trespass conviction, 2011 violate family violence order, nolo plea, a 2011 simple battery conviction, 2008 criminal trespass conviction, and a total of two probation violations and nothing further.
Thank you. Ms. Waldrop?
Yes, Judge. The defendant is charged with one count of reckless conduct. And Your Honor, that stems from an incident in which the defendant actually pursued another driver while on I-20, Mr. Derek Jackson, who he mistakenly thought had hit his vehicle. And he pursued Mr. Jackson with a gun in hand. He brandished that weapon such that Mr. Jackson was able to see it and inform officers of it. And it was later found in the defendant's vehicle. And ultimately, this caused Mr. Jackson to try to get away from the defendant. And as he was doing that, he swerved, hit another vehicle, and collided with another vehicle, causing an accident. So, Your Honor, with regard to the state's recommendation on bond, given the factual basis for the allegation, as well as the history that you just heard read by pretrial and the danger that he posed to not only Mr. Jackson, but other innocent motorists on the roadway, that particular day, the state is requesting a $15,000 straight bond. We are requesting that he have no further contact with Mr. Derek Jackson, that he have no weapons on or about his person while out on bond, and no drugs or alcohol.
I'm going to sound for Mr. Jackson. Mr. Jackson, if you're here and wish to be heard, this is your opportunity to speak. All right, hearing none, Mr. Ford.
Thank you, Your Honor. Your Honor, my client is 36 years old. He has an associate's degree in engineering. He was working for a laboratory, but he is just, because of this case, has just lost his job. His employment there to get out of jail quickly here. Your Honor, if you listen to pretrial services, he has no felonies. His last case was a driving while license suspended. The other cases go back to 2016, which was a marijuana case. The only violent history was back in 2011, which was only a simple, just a simple battery. He has a stable address here in Georgia. Telephone number also, he has community support. I received the telephone number of his mother. He's a lifetime resident of Georgia, Your Honor. I would hope that a signature bond could be granted in this particular case due to the fact that Mr. McCullough could receive his job back, which I think is definite something that he needs to have happen at this time based on his background. So at this time, Your Honor, we're requesting a signature bond.
All right, at this time, Mr. McCullough is going to receive a $2,000 surety bond. He is to have no weapons, drugs, or alcohol, including the subject weapon of this case. He'll need to surrender that. And he is to have no further contact with the alleged victim in this case, last name Jackson. Is there anything further from either the state or the defense?
No, Judge.
All right,
What was the bond amount again?
2,000 surety.
All right, thank you.
All right, best of luck to you, sir. Who do we have next?
Next is position 14, Mr. Reed. Hold on.
All right, good afternoon, Mr. Reed. Your case number is 22 CR 004823D, in which you're charged with theft by taking with the offense date of July the 20th of 2022. Do you understand your constitutional rights?
Yeah.
All right, Ms. Roberts.
19 cycles. Last arrested in 2016 for a probation violation. And the underlying charge was criminal attempt to commit burglary, which was from, I believe, 2006. Yes. He had a 2006 conviction for criminal attempt to commit a felony in possession of tools for commission of a crime. That's the most recent conviction, 2006. 2005 conviction for purchase, possession, have a controlled substance, and abandonment of certain drugs. A 1992 conviction for burglary, 92 conviction for criminal trespass, 91 criminal trespass, 1990 dangerous drugs, 1990, and abandonment of certain drugs and carrying a pistol without a license, 1991. He's also recommended.
All right, thank you. Ms. Waldrop, is this Ms. Waldrop or Ms. Williams? Ms. Waldrop, I believe it's you.
It is, Your Honor. And I know that you heard from pretrial that the last conviction was in 2006. However, this defendant has a multitude of burglary and theft arrests. With regard to this particular case, he came on to the private property of Mr. Marcel Cotman, who I believe is on the line today, and took property that belonging to him off of his porch. Mr. Cotman ended up sharing footage of this theft with others in the neighborhood who indicated that they also had their items taken from their porch as well. With respect to the state's recommendation on bond, the state would request a $1,500 straight bond. We would ask that he stay away from the location of 281 Atlanta Avenue, that the defendant have no drugs or alcohol, and no weapons on or about his person.
All right, thank you. I'm gonna hear from Mr. Cotman if you'd like to make a statement. Mr. Cotman, if you'd like to, you need to turn on your camera. You're not required to do so, but if you'd like to, this is your opportunity to speak. Would you like to make a statement today?
Yes, Judge. We just wanted to express.
Please raise your right hand. I swear you in. Do you swear and affirm the testimony you give today will be the truth to the best of your knowledge and under the penalty of perjury?
Yes.
All right, very briefly, go ahead, Mr. Cotman. What would you like to tell me today?
No, Judge, we'd like to express our concern as, the case is stated, as well as hearing from some of our other neighbors about the, burglary threat that he poses to the neighborhood. And so just want to make sure like that, not in addition to our address, just our neighborhood in general, if he could be asked or forced to stay away from our neighborhood as well.
All right, thank you. Did you want to tell me anything else, Mr. Cotman?
No, that was it.
All right, thank you. I appreciate you coming to court and making that statement here today. Ms. Helen, please proceed.
Yes, Judge. Mr. Reed is 59 years old. Just go to the Ayala factors. Right now, he's not currently working. He is residentially challenged. He's from Georgia, but he does not have any children. Judge, I don't know if you read the police report, but it did state that mosquito repellent was taken from a Mr. Marcel Cotman. But I know that you've heard Mr. Reed's history. I think it was 16 years ago, 2006. For an actual conviction on theft. I do hear Mr. Cotman's concerns. However, for today's case, for this theft by taking, I am asking for a signature bond on behalf of Mr. Reed because again, he's residentially challenged. He has no income. He will not be able to post that bond at all, not a penny from it, Judge. And if he is not eligible for that signature bond, we are asking a surety bond of no more than $500.
All right, thank you. Ms.
And Your Honor,
Waldrop.
if I may.
Yes, very briefly, Ms. Waldrop.
Sure. Very briefly, as defense counsel just admitted, if he's residentially challenged, then the state certainly has a concern about whether or not he would be able to receive notices for court and return to court. And also, of course, we're concerned about him going back to that same neighborhood, given that he has no place to go.
All right, I understand that, Ms. Waldrop, but again, I'm not sure that the Fulton County Jail is an ideal place either. At this time, Mr. Reed is going to receive an $8,000 signature bond through the jail. He is to stay away not only from the address on Atlanta Avenue, but the entire neighborhood. Mr. Cotman, is there a name of your subdivision, perhaps?
Yes, we are in Peoplestown, and also he's been spotted in the Summer Hill neighborhood as well as Grant Park.
Okay, well, I can't restrict him from going to all of them.
Yeah, I understood. Yeah, we are specifically
that's
in
ideal. We
Peoplestown.
will not restrict it from there. Mr. Reed, I'm directing you, do not go back to that street in its entirety. And even if you're around roaming, please don't do this again. I'm giving you an opportunity here. All right? You understand that? All right. All right. And you are also have no weapons, drugs, or alcohol as a condition of that signature bond through the jail. All right, I believe that will conclude Mr. Reed's case. Is there anything further from either the state or the defense?
No, Your Honor.
Yes, Your Honor, just wanted to clarify, was that the Peoplestown neighborhood? I just want to get the name right.
Peoplestown is pretty large as well.
Oh, okay.
I'm going to restrict him from the entire street. I was hoping there was a subdivision name or something that I could place, but I understand that it's not. And Peoplestown does neighbor Summer Hill and Grant Park. I don't think I can restrict him from there. So I'm just going to restrict him from that entire street. And he is to stay 1,000 yards away from that street on either side. So that is full football field, Mr. Reed. Do not go close to that street. All right. Best of luck to you, sir. Who do we have next?
Position number 11. You got it, Mr. Reed.
All right. Position 11, Mr. Rodriguez Jackson. Mr. Jackson, your case number is 22 CR 004835E. And what you're charged with one count of giving false information to a law enforcement officer. Do you understand your constitutional rights?
Yes, yes, Your Honor.
All right, Ms. Robert.
25 cycles. Last arrest was April of 2021 for theft by taking and hit and run. Duty of driver to stop at or return to the scene of accident. That is an open case, 22 SC 183278. He appears to be on probation for burglary in the second degree. 17 SC 154986. Disposition January of 2018, 7 years probation. He also appears to be on probation for theft by receiving stolen property. 18 SC 164045. Disposition April of 2019, 4 years probation. He has a total of 3 FTAs, 1 in 2019, 2 in 2014, a driving without a valid license conviction, 2013, a 2010 theft by receiving stolen property conviction, and then a total of 3 probation violations, and nothing further.
Thank you, Ms. Roberts. Ms. Waldrop.
Yes, Your Honor, with regard to a brief factual basis, the defendant in this case used his alias name of Aaron Jackson when he was detained and officers were trying to confirm his identity. As you heard from pretrial, he has an extensive history of varied arrests as well as probation violations and failures to appear. The defendant also currently has a probation warrant, I believe, for the theft by taking and hit and run case that you heard mentioned. And Your Honor, with regard to that warrant, they went to serve it at his last known address of 1460 Sylvan Road and determined that he no longer lived there. So there's no good address for the defendant for him to receive notices or even for the probation officer to make their visits. With regard to the charge and the state's recommendation on bond, we are requesting a $2,000 straight bond, no weapons, no drugs or alcohol while out on bond. And we would ask that the defendant provide a address that can be verified with regard to where it is that he lives.
All right, thank you. Ms. Helen?
I'm sorry, Judge, I didn't hear you. What was that?
Your turn, Ms. Helen.
Yes, Judge. So Mr. Jackson is 31 years old. When I spoke to him, this is about giving false information to the officer. He understood the seriousness of this case. He understood that there's an open case of that theft by taking, as well as those probation cases. But Judge, he's not currently working right now. However, he's a high school graduate from Douglas High School. He is a lifetime resident of Fulton County, so he will appear to his court dates. I do not believe that he will not appear. He is a proud father of 9 girls, 19, 16, 14, 11, 7, 5, 3, and 2, Judge. So this is a father of 9 girls. He has graduated from high school. And again, for this case, we're asking for a $500 signature bond. With these open cases, he will be coming to court. I do not believe he will be receiving any more new cases while this case is still open, Judge. So I am requesting a $500 signature bond for this case.
All right, at this time, Mr. Jackson is going to receive a $2,000 signature bond through the jail. I am ordering that he place contact information for himself. I'm sorry, Ms. Helen, that stroke of genius just occurred to you?
Yes, I did speak to Mr. Jackson. He confirmed the 1460 Sylvan Road, Southwest Atlanta, also gave me a contact number. So Mr. Jackson, if you would like to give another address to the—
shaking her head and indicating that address is erroneous and false.
Okay, cool. Mr. Jackson, give us the better address.
Okay, look, I don't live there, but my
Wait, Mr. Jackson, Mr. Jackson, no. We are asking for an address that we can find you at. I have the number. We just need an address, no explanation. Do you have an address?
Okay, yeah, I can give you my mom's address.
Okay.
732 Duffield Drive.
Say it again.
732 Duffield Drive.
Duffield Drive. City, state, zip code.
I'm Georgia, 303. I don't know the zip code. I think it's either 18, 30318.
And your mother's name, Mr. Jackson?
Sabrina Archer.
All right. And we're going to ask for one other relative's name and address. Do you
One
have
more person to contact? Dad?
I can give you my uncle. 678 596 8345.
What's uncle's name?
Timothy Somerville.
Who's coming to pick you up from court today, Mr. Jackson?
Who's coming
from jail today?
Oh, Judge, he has other things holding him at the jail. Isn't that right, Mr. Jackson?
He has other holds. Okay, understood. Yeah. That is clear. All right. I believe we have some contact information. It does not sound like his release is imminent. So hopefully that those addresses will be sufficient for him to receive further notices. I believe that will conclude Mr. Jackson's case. All right, who do we have next? Are we? Oh, we are.
We have position 9 Harris, but Mr. Dockett refused to come back to the courtroom.
I'm sorry, what position was that?
This is position number 9.
Oh, this is 9, but who refused to come?
Mr. Dockett, he's position number, position number 7. He refused to return.
Oh, Mr. Dockery refused to come to court?
Yes.
All right, Mr. Ford, do you represent him, position 7?
No, Your Honor, he was a conflict.
Oh, he was a conflict anyway, so he refused to come. Reset till Mondays, SCA. All right, Good afternoon, Mr. Harris. Your case number is 22 CR 004834A, in which you're charged with one count of battery family violence with the offense date of June the 23rd of 2022. Do you understand your constitutional rights?
Yes, ma'am.
All right, Ms. Roberts.
Which
Ms. Roberts,
position, Judge?
position 9.
16 cycles, 13 out of California, 3 out of Georgia. Last arrest was May of this year for driving under the influence in LaGrange. He appears to have an open case out of Fulton County for purchase, possession, or have a control of any controlled substance in Schedule 1 or narcotic in Schedule 2, trafficking in cocaine, illegal drugs, marijuana, or meth, and possession of a firearm or a knife during the commission of or attempt to commit certain felonies, 21 CP 203109. And he also appears to have an open case out of Clayton County for theft by receiving stolen property. He has a conviction. Well, he has an FTA out of California from 2006. Driving while license suspended conviction from 2007 out of California. A FTA from 2005 out of California. A DUI conviction from 2003 out of California. Driving while license suspended conviction 2003 California. And nothing further to add.
Thank you. Ms. Williams?
Yes, Your Honor. In this case, the state recommends a $20,000 good bond and no further contact with LaToya Dunn and a stay away from 3950 Cascade Palmetto Highway in South Fulton, Georgia. Your Honor, in this case, once the police arrived, the victim, Miss LaToya Dunn, advised that the defendant was out drinking, and while he was gone, she had a friend over at the house, and while he was when he came back, the friend of hers was still there, and all did seem just fine until the other party left. And once he did leave, an argument ensued that became very violent when the defendant repeatedly punched Miss Dunn in the face, and the officer was able to observe a number of injuries, including both of her eyes being swollen, her lip being busted, bleeding from her nose, and also an abrasion above her left eyebrow.
All right. I'm going to sound for Ms. Dunn at this time. If Ms. Dunn is present on the Zoom conference and wishes to be heard, hearing none. Is this also a conflict case? Does anybody represent Mr. Harris?
He's a conflict, Judge.
Okay, I just wanted to confirm.
Yeah,
Mr.
he
Harris,
is a
you have, all right, just wanted to confirm. Mr. Harris, you have a right to an attorney at this proceeding, and there is no conflict attorney present to represent you because the public defender's office is unable to assist you. So I'm going to give you a surety bond today and reset your case to the SEA calendar on Monday, whereby hopefully a conflict attorney will be present then to assist you, okay? I'm still gonna set a bond for you today. You're gonna receive a $7,500 surety bond. You're to have no further contact with the alleged victim, Miss Dunn, and you are to have no weapons, drugs, or alcohol as a condition of this surety bond. And as I stated, you'll be reset to Monday's calendar where your case will be revisited at that time, and it's my hope that a conflict attorney will be present to assist you.
And
You
Your
can
Honor, can we
ask-
also have I'm sorry.
Go ahead, Ms. Williams.
In case he is able to make that bond, I wanted to see if we could include the stay away, Your Honor.
Oh, yes, and he must stay away from that address on Cascade Palmetto Highway. I apologize, yes. Now, Mr. Harris, you can ask me a very limited question about the bond, but remember the state is listening, and I don't want you to inadvertently say something that they're gonna use against you. So what is your question?
Oh, this is Monday. Can I try to get the bond lowered or to a signature or something like that?
Monday, an attorney will be present that you'll be able to speak to, who will interview you. And if you have representation at that time, they should be able to assist you with this, okay? I don't want to hear bond arguments from you because the state is listening and you may end up giving your defense away, all right? So you'll be revisited on Monday. whereby they might be able to lower your bond or revisit it or present additional facts, okay?
Okay.
All right, best of luck to you, Mr. Harris. That will conclude your case at this time. We still have add-on 1. Is that person still at courtroom, at the courtroom?
What was the name?
Quentin Jones.
We didn't have him in courtroom 1.
He was a conflict
He
as
was a
well, Judge.
conflict. He was a conflict as well, Your Honor.
Are we able to get Mr. Jones so I can set a bond today?
Hold on, Judge.
All right. Do we want to review the calendar in the meantime?
And
And
Judge, just so you know, Mr. Jones was on the felony calendar this morning and he received no bond.
Okay, well, he's essentially he won't be getting out anyway, but we still would like to set a bond today for this charge if possible. While we wait, it may not even be possible for us to get Mr. Jones. But yes, Ms. Waldrop, go ahead.
Your Honor, I just wanted to inquire, was he on the felony calendar for this case, for this charge?
That's a
What's
great
this
question.
charge? He was on, it was a firearm charge that he was in felony for, possession of a firearm by convicted felon.
Thank you.
All right, so if we can get him a first appearance on this case, that would be ideal. It may not be possible. In the meantime, can we review the calendar, Ms. Middlebrooks, and then we'll take position 1. I mean, that position 1 on the add-on if we can, and if not, that will conclude our our hearings today.
I'm ready, Your Honor. Position number 1 will be reset to Monday's SEA calendar, July 25th. Position number 2 received a $2,000 sign-on bond through the jail. Position number 3 received a $5,000 good bond, reset SAP August 4th. Position number 4 received a $4,000 sign-on bond through the jail, reset further notice. Position number 5 received a $6,000 good bond, reset SAP August 4th. Position number 6 received a $3,500 good bond, reset SAP August 4th. Position number 7 will be reset to Monday's SCA calendar, July 25th. Position number 8 received a $2,000 split bond, reset SAP August 4th. Position number 9 received a $7,500 good bond, reset SCA Monday, July 25th. Position number 10 received a $3,000 sign-on bond through pretrial, reset further notice. Position number 11 received a $2,000 sign-on bond through the jail, reset further notice. Position number 12 received a $6,000 sign-on bond through pretrial, reset further notice. Position 13 received a $5,500 good bond, reset SAP August the 4th. Position 14 received a $8,000 sign-on bond through the jail, reset further notice. Position 15 received a $3,000 good bond. She was reset to the SCA calendar on Monday, July 25th. Position 16 received a $2,500 good bond, reset SAP August 4th. That was position 16. Position number 2 on the add-on calendar received a $2,000 good bond, reset SAP August 4th.
And we have add-on 1, Quentin Jones.
All right, thank you. Any comments, changes, corrections, or questions as it pertains to the review of the calendar?
Yes, Your Honor. On position 3, they mentioned a $5,000 good bond for the battery, but I think you also assigned a $2,500 good bond for the simple battery.
It was a $5,000 total.
Was it total?
Yes.
Okay, so it's $2,500 apiece. Okay.
All right. Good afternoon, Mr. Jones. Your case number is 22 CR 004837F, in which you're charged with battery with the offense date of July the 22nd. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to an attorney. However, no attorney is present to represent you, so your case will likely be reset to Monday as well. But I did want to set an initial bond and give you a first appearance. And at that time, hopefully a conflict attorney will be present to assist you. Ms. Roberts, can I please have the history?
Yes,
Yeah.
33 cycles, 17 out of Tennessee, 15 out of Florida, 1 out of Georgia. Last arrest was April of 2019 for aggravated assault, family violence, 3 counts of cruelty and aggravated assault strangulation. He is currently on probation for that case, 19 SC. He's on first offender probation, 19 SC 170025. Disposition November 2019, 1 year confinement, 4 years probation. He has 2 FTAs out of Tennessee, 2014, 2013. He has 3 probation violations out of Tennessee, 2012 and 2 in 2016. He has a conviction for possession of a controlled substance, 2015, Tennessee. Assault conviction, 2014, Tennessee. A possession of a controlled substance, 2013, Tennessee.
I've got it. Thank you. That was very thorough. I appreciate it. Thank you. I'm sure Ms. Williams will add as well. Ms. Williams, the state's position?
That's actually going to be my case, Judge.
Oh, I continue to get that wrong. I'm gonna stop guessing. Ms. Waldrop, the state's position, please.
Yes, Judge. You heard pretrial's recitation of his criminal history. I do want to point out that that open case of the possession of a firearm by convicted felon and reckless conduct that he had first appearance on, I think a day ago, or excuse me, this morning, as you heard this morning. It was when he was in Fulton County Jail on that case that he picked up this new case. And so just briefly, the facts on this new case are that there was another inmate, Mr. Fernando de la Rosa, who was entering into a cell where the defendant was located. Upon that door being opened, the defendant aggressively ran towards Mr. de la Rosa, punched him one time in the left side of his face, causing him to bleed from his eye and nose. Your Honor, with respect to the state's recommendation on bond, we would be asking for a $7,500 straight bond and no further contact with Mr. Fernando de la Rosa.
All right. I know you have a question, Mr. Jones, but I don't want you to inadvertently ask or say something to me that the state will hear and use against you. I want to make you aware again of your constitutional rights to remain silent. But what is your question, Mr. Jones?
It was due to that, what she was just saying, but I'll take what you said, Your Honor, and
Yeah, please don't say, I appreciate that. Don't say anything because you never know what you might say that ends up being used against you, all right? At this time, I'm going to accept the state's recommendation and give Mr. Jones a $7,500 good bond. He is to have no further contact with the alleged victim in this case and also have no weapons, drugs, or alcohol. Your case will also be reset to the Monday SEA calendar whereby this can be revisited. All right, best of luck to you, Mr. Jones. Is there anything further from either the state or the defense as it pertains to this case?
No, Your Honor.
I believe that concludes all of our business today. We will be in recess until the 7:25 SCA calendar, at which time I believe Judge Morrow will be presiding. Take care, everyone. Enjoy the rest of your weekend. Have a good
Thank you, Judge.
Thank you, Your Honor.
All right, bye-bye.
Bye-bye.